The European Account Preservation Order: Background, Scope, and Jurisdiction. Background. Differences between national legal systems exist, in particular with respect to the conditions for issue and the implementation of protective measures. At present, it is more cumbersome, lengthy, and costly for a creditor to obtain provisional measures to preserve assets of their debtor located in another member state. This is a problem because quick and easy access to such provisional measures is often crucial to ensure that the debtor has not removed or dissipated their assets by the time the creditor has obtained and enforced the judgment on the merits. This is particularly important with regard to assets in bank accounts. Currently, debtors can easily escape enforcement measures by swiftly moving their monies from a bank account in one member state to another. A creditor, however, has difficulty blocking a debtor's bank accounts abroad to secure the payment of their claim. As a result, many creditors are either unable to successfully recover their claims abroad or do not consider it worthwhile pursuing them and write them off. For these reasons, the European Commission took the initiative to make a proposal for a European Account Preservation Order to prevent the removal of money from bank accounts to the detriment of creditors. The resulting regulation was adopted on the 15th of May 2014 and will apply from the 18th of January 2017. Territorial scope of application. The regulation binds all the EU member states with the exception of Denmark and the United Kingdom, which did not opt in. Creditors domiciled in a member state not bound by the regulation or non-EU states cannot avail themselves of the procedure even if the competent court or the account or accounts involved are maintained in member states which are so bound. The preservation order can only operate against bank accounts maintained in one or more member states bound by the regulation, though the accounts do not have to be with a bank which is based in the EU, provided that in such a case they are held by a branch situated within the EU. Use of the preservation order is limited to cross-border cases. A cross-border case is one in which the bank account or accounts to be the subject of the order are maintained in a member state other than that of the court ceased of the application for the order or the member state in which the creditor is domiciled. Material scope of application and availability. The procedure can be used for pecuniary claims in civil and commercial matters. There are some exclusions from scope, which are similar to those in the Regulation Brussels I. In addition, the procedure cannot be used to secure funds at credit of accounts held in banks which are immune from seizure under the relevant national law, nor accounts held by or with the central banks acting as monetary authorities. The procedure can be used by a creditor either before or after an order is obtained. It is also available for use to enforce an obligation expressed in an authentic instrument or contained in a court settlement. The procedure established by the regulation is available to creditors as an alternative to the procedures already available under the national laws of the member states. Jurisdiction. The courts of the member state, where jurisdiction on the substance lies, have jurisdiction to issue a European Account Preservation Order where the creditor has yet to obtain a judgment, court settlement, or authentic instrument. There are special rules for consumer debtors whereby only the court of the consumer's domicile has jurisdiction against the creditor. After the creditor has obtained a judgment, court settlement, or authentic instrument, the courts in the member state where the judgment, settlement, or authentic instrument in question was granted shall have jurisdiction.